You see the flashing red and blue lights in your rearview mirror. Your heart drops into your stomach. A surge of adrenaline, cold and sharp, floods your system. Your mind races. Was I swerving? What's my speed? Did I signal? Then, the more dreadful thought emerges. I had a drink earlier, or two. What you do and say in the next 10 minutes could determine the next 10 years of your life. The traffic stop is not a conversation. It is an interrogation. The officer is not your friend. He is a trained investigator gathering evidence to build a case against you. The law, in its majestic equality, grants you rights, but only if you know how to invoke them with calm, precise language. This is not a game of luck. It is a procedural chess match, and you're already at a severe disadvantage. You must know the moves. This guide provides the blueprint. What follows is the stark, realistic, and legally informed strategy every driver must understand, distilled from the direct experience of criminal defense attorneys who spend their careers cleaning up the catastrophic messes made in those first few panic moments on the roadside. The foundation, understanding the battlefield. Before we delve into the specific phrases, you must internalize the legal landscape of a DWI, driving while intoxicated, or DUI, driving under the influence, stop. In the eyes of the law, a traffic stop is a temporary seizure. The officer must have reasonable suspicion to initiate it, a traffic violation, erratic driving, etc. Once the stop begins, the officer's goal is to quickly gather evidence to elevate that reasonable suspicion into probable cause for an arrest. This evidence comes in three primary forms. Observational evidence, your driving pattern, your physical appearance, bloodshot eyes, flushed face, the odor of alcohol, your speech pattern, your coordination. Verbal evidence, everything you say. This is the most damaging evidence people freely provide. Field sobriety test, FST, and chemical test evidence. The performance on physical tests, walk and turn, one-leg stand, etc., and the ultimate breath or blood test result. Crucially, the first two categories are entirely within your control to limit. The officer's toolkit is designed to get you to incriminate yourself. The friendly chat, the seemingly innocent questions are all structured to elicit admissions and observations. Where are you headed tonight? To see if your story is slurred or illogical. Have you had anything to drink tonight? The direct admission trap. Any answer beyond a polite, limited invocation of your rights feeds the state's case. Remember this core legal principle. You have an absolute right to remain silent under the Fifth Amendment, and you have a right to be free from unreasonable searches under the Fourth Amendment. Asserting these rights cannot be used against you as evidence of guilt in a court of law. The officer may dislike it, and it may almost certainly lead to your arrest, but your arrest at that point will be based on far less evidence than if you had performed tests and given a full verbal confession on the roadside. An arrest is not a conviction. Your goal is not to avoid arrest at all costs. Your goal is to avoid giving the prosecution the evidence it needs to secure a conviction. Phase 1. The initial stop, the calm before the storm. The officer approaches your vehicle. Your job is to be safe, polite, and minimally compliant. Your actions: pull over safely, turn off the engine, roll down your window fully, and place your hands on the steering wheel where they are visible. If it's dark, turn on your interior dome light. This addresses officer safety concerns and sets a tone of non-confrontation. The officer's script. They will greet you, state their name and agency, and ask for your license, registration, and proof of insurance. Your script: good evening, officer. I will provide my documents for you. Retrieve them slowly and deliberately, informing the officer if you need to reach into the glove compartment or center console. Hand them over. What not to do: do not volunteer information. Do not say, "What's the problem, officer?" or "Was I speeding?" Do not fumble nervously or make sudden movements. Do not apologize for a violation you're not sure you committed. It can be an admission. At this point, the officer is assessing you. They're smelling the air from your car, looking at your eyes, listening to your speech. Your job is to give them as little as possible. Phase 2. The interrogation begins, the critical moment. Here is where the friendly questioning starts. This is the pivot point. The officer will almost always ask open-ended questions designed to get you talking. The most dangerous question: do you know why I pulled you over? The trap: if you guess, was I speeding, you admit to a violation, providing the reasonable suspicion they may not have even it solidly. If you say you don't know, they may press. Any answer is a landmine. The lawyer-recommended response: I'm not sure, officer. Say it politely and neutrally. Stop talking. The nuclear bomb question: have you had anything to drink tonight? Or how much have you had to drink? The trap: any admission is catastrophic. Just 2 beers is the classic devastating answer. People universally underestimate, and their 2 beers is often the prosecution's cornerstone. Even 1 glass of wine with dinner establishes you consumed alcohol. Lying nothing is also terrible if you later blow over the limit, as it shows consciousness of guilt. The lawyer-recommended response: this is where you must deploy your rights. Calmly and clearly state, officer, on the advice of counsel, I am exercising my right to remain silent. I respectfully decline to answer any questions. This statement is not rude. It is not confrontational. It is a constitutional invocation. Say it, and then stop talking. You have drawn a bright, legal line. The officer's playbook now changes. Phase 3: the exit request and field sobriety tests. Frustrated by your silence, the officer will almost certainly say, step out of the car, please. You must comply. Exiting the vehicle is a lawful order. Do so carefully. Outside the car, the officer will likely say, I'd like you to perform some standard field sobriety tests so I can make sure you're safe to drive. This is presented as a choice, a way to clear things up and be on your way. This is the single most deceptive part of the encounter. You must understand, field sobriety tests, FSTs, are voluntary, and they are designed for you to fail. The National Highway Traffic Safety Administration, NHTSA, standardized tests, horizontal gaze nystagmus, walk and turn, one-leg stand, are difficult. They are administered on uneven, sloped, gravel-strewn roads in stressful conditions, with traffic whizzing by, wearing street shoes, with flashing patrol car lights in your eyes. The scoring is subjective. Even completely sober people can struggle. The officer is not testing you to see if you pass. They're building a checklist of clues of impairment. Your script: officer, I do not consent to any field sobriety tests. On the advice of counsel, I am exercising my right to remain silent. You can add, I am happy to cooperate with providing my license and registration, but I will not perform any voluntary tests or answer any questions. The prelim breath test, PBD, the officer may produce a small handheld breathalyzer. This is not the official evidentiary test. This is another voluntary field test. Its results are often inadmissible at trial for proving BAC, but they provide the officer with the probable cause they desperately need. Your refusal may be admissible to show consciousness of guilt, but it denies them a key data point. Your script: I do not consent to a preliminary breath test. What happens now? The officer's evidence is limited to their initial observation, driving, odor, your silence, and your refusal of tests. Based on this, especially the odor of alcohol combined with your refusal, they will almost certainly place you under arrest. This is okay. You have forced them to make an arrest decision on the thinnest possible evidence. You have protected your case. Here is a question for you, based on a real case. A man is stopped after leaving a bar. He says he had 2 beers. He performs the walk and turn test perfectly, but stumbles once on the one-leg stand. He blows a 0.08% on the roadside PBT. He is arrested and later blows a 0.09% at the station. His license is suspended. What single piece of evidence, had he withheld it, would have given his attorney the best chance to win a trial? Pause and think, then share your answer in the comments below. Phase 4. After the arrest, the chemical test decision. You are placed in handcuffs, read your Miranda rights, usually, and taken to the station or a mobile testing unit. This is a new phase governed by implied consent laws. By driving on the roads of your state, you have already consented to taking a chemical test, breath, blood, or sometimes urine, if you are lawfully arrested for DWI. Refusal of this official test carries severe administrative penalties that are separate from the criminal case. An automatic, lengthy driver's license suspension, often 12 to 18 months, sometimes longer, and potentially being forced to install an ignition interlock device. This is the most complex decision point, and there is no one-size-fits-all answer. A lawyer cannot make it for you in the moment. You must understand the trade-offs. Taking the test. Pro. You avoid the harsh administrative penalties for refusal. If the result is under the legal limit, 0.08% in all states, it is powerful evidence for your release and defense. Con. If the result is over the limit, the prosecution has a scientific, highly damaging piece of evidence. While a good attorney can challenge the machine's calibration, the operator's training, and the procedure, it is an uphill battle. Refusing the test. Pro. You deprive the state of the single most powerful piece of evidence, the number. The criminal case rests on the weaker, more attackable observational evidence. Con. You will face the automatic license suspension and other civil penalties. The prosecution may also argue at trial that your refusal shows you knew you were guilty. Lawyer analysis. There is a strong strategic argument for refusal if you are confident you are over the limit. The criminal case becomes much harder to prove beyond a reasonable doubt. You fight the criminal charge while separately dealing with the Department of Motor Vehicles in an administrative hearing, where you have a right to counsel. However, if there is a chance you are under the limit, or if your livelihood depends on your driver's license, taking the test may be the prudent choice. Your script. If you choose to refuse the official test, I do not consent to any chemical testing. I want to speak with an attorney. Note, in most states, you do not have a right to consult an attorney before making this decision, but asking for one cannot hurt. The aftermath and the attorney. From the moment of arrest forward, your only statement should be, I am invoking my right to remain silent. I want to speak to an attorney. Repeat it as a mantra. Do not engage in booking chatter. Do not complain to the cellmate. Do not make phone calls you think are private. Everything is recorded. Your first call should be to a bondsman and then to a specialized DWI defense attorney. When you speak to the attorney, you can and should tell them everything. That conversation is protected by attorney-client privilege. Why the strategy works. A legal view from the defense table. At trial, the prosecution's case is a story. They want to tell the jury, the defendant was drunk, drove dangerously, admitted to drinking, failed tests, and confirmed it with a breath machine. Your attorney's job is to dismantle that story chapter by chapter. Chapter 1. The driving my client's taillight was out, not a sign of impairment. Chapter 2. The admission there is none. The jury never hears, I had 2 beers. The officer can only testify that the defendant was polite but silent. This is a massive hole in the story. Chapter 3. The FSTs, they don't exist. The defense attorney can argue the officer had nothing but an odor, which could be from the passenger or residual, and made a premature arrest. No video of a struggling performance exists. Chapter 4. The chemical test, either it's a refusal, and the attorney will attack the reasonableness of the arrest itself, or a number that can be challenged technically. Without your words and your performance on the tests, the case often collapses. Prosecutors may offer drastically reduced charges or even dismiss. A final, sobering reality. This is not about getting off on a technicality. It is about forcing the state to meet its high burden of proof as the Constitution requires. The system is weighted against you. The tests are unfair. The pressure to comply is immense. Knowing and using these precise phrases is your only shield. You must practice them. You must discuss this strategy with your family. The panic of the moment is the prosecutor's greatest ally. Arm yourself with calm, constitutional words. If you found this detailed, lawyer-informed breakdown valuable, imagine having this level of strategic knowledge for other legal situations. We provide that knowledge here. To ensure you and those you care about are never caught unprepared, subscribe to the channel. Hit the subscribe button and turn on notifications. Your future self may thank you.